Oh, we're getting somewhere now. Is it showing? Sorry, y'all, they painted in here and they disconnected everything up here and we're just trying to get back to where we were. It's got a sign. See, I never sign out, so now. Yeah. It's trying. No, what just happened? Yeah, I think something just happened to it. Yeah, here we go. This TV to pop on. Aha. William, we working out there? See? All right. We out there good? Yeah. I'll go get my robe and I'll get started. No, it's just here. It's a new world we live in. Whenever you're ready, just let me know. We're still getting Melanie set up. They painted it everywhere in here. You're good? I don't think we have anybody appearing via Zoom, but if we do, we're up. All right, this is cause number 2014B-0087. In the interest of, I'm just going to call it CD, since we're on YouTube, JD and TD that are children. And this is set today on a motion for new trial. And so if we could, beginning with the department, just make an announcement on the record of your appearance, please.
Elise Donnelly for the department.
And then going down through the line. Okay. And I will say this, and I guess to get some housekeeping notes out of the way. Y'all don't have to wear those masks if you don't want to. If you do, it's up to you. It's your individual decision. But keep in mind, somebody may be beside you. You may want to wear a mask and they may not be. And so I will tell you this, it makes it a lot easier for us to hear if you don't have it on when you're speaking. But again, whatever you choose to do, I'm not going to judge you one way or the other. And then who else do we have here? Okay, is anyone else going to testify?
Yes.
Okay.
Worker eventually will also be your honor.
Even though I know who you are, just for the record.
Yes. So volunteer Brenda Hope.
Okay. All right. If I can get everyone that's going to testify to go ahead and raise your right hand, I'm going to swear each of you in now. Each of you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God. Now you can lower your hands. And now that we're getting started, this is a motion for new trial. And I'll tell you, I remember this case. Yeah, I kind of remember all of them, but I remember this one in particular because I believe this was a termination based upon a mediated settlement agreement. Is that correct? Yes, no?
Judge, there was a mediated settlement in this case where the parties had agreed to sign an affidavit of voluntary relinquishment should certain things occur or not occur for the mediated settlement agreement. There was a fight over that mediated settlement agreement, and maybe we're here for that hearing as to whether or not the mediated settlement agreement was pulled. A deal was reached in the Spencer on that day.
Okay, so the department's position is, and I'll allow you to respond, is there was a mediated settlement agreement that was conditioned on some things happening. And is it the department's position that those things did not happen?
Yes, it is the department's decision that those things did not happen. And for the mediated settlement agreement, Spencer should have signed the affidavit of voluntary relinquishment anyway. Like I said, there was a fight, there was a repudiation of that mediated settlement agreement. We set a hearing for the date of August 4th, 2020. We were here for that hearing date. The parties, all of the parties together worked out a deal that was sort of separate and a slightly different from the mediated settlement.
So on a mediated settlement agreement, so basically the department then repudiated it as well if you sign another deal, is that correct?
Well, we signed a final order, Judge, that was slightly different.
That's not my question though.
That's
So
correct.
if there's a mediated settlement agreement and one side says, I'm repudiating it, I don't want to do it, and the other side works out a new deal, aren't they in fact then going along with that,
Yes,
consenting in that?
I actually agree with you. I don't think the issue here necessarily is the mediated settlement agreement. It's that she signed an affidavit of voluntary relinquishment under a new deal that was memorialized in the final.
Okay. And then if I could, and I promise Mr. Harrington, I'm gonna let you respond to all of it. I'm just trying to get my bearings straight. Was this the case where there were some allegations that the caregivers of the children were coaching the children? Is this that same case?
Yes, I believe that is correct. Different caregivers early in the case, but different caregivers than where the children are currently having.
And wasn't the position was that the mediated settlement agreement was entered into based upon these allegations that the children supposedly made, but later it was found out they may have been coached? At least there's a position there somewhere, is that correct?
I believe there is a position. that
Right.
is concerned about that.
Judge, if I may interject, as the attorney for the children, the allegations that the children were coached, not coached to say certain things, coached as to their behavior.
Right.
So that the caregivers could get more money for each child. so that their level of care would be raised. That was the coaching that went on. That was, yeah. and that-
Before the mediated settlement agreement was entered into.
Say that again, I'm sorry.
So this coaching would have occurred before the mediated settlement agreement was entered into.
Yes, so from the very beginning, to get the children's level of care raised.
And this was also, this also had a companion, well, I don't even want to call it a companion. Did this case also have a criminal case that was eventually dismissed by the state?
I don't know the disposition of it, but nothing happened with it.
And just for the record, I think I signed the warrant on that case. Okay. All right, Mr. Harrington, now that we have it all out there.
Well, this is a very interesting case. I think where this issue starts back, we get settlement agreement back in, I believe September 2018. Part of the agreement at that time was, it was going to be an interim order entered with the court, and they're going to call it a final order, but it's not really a final order. So that was one of the terms in there of the settlement agreement. The immediate settlement agreement was that the mother would terminate her parental rights based upon CPS investigating some parents or family members if they would name. Then I guess it would be sole discretion of the part of the department whether or not to approve those placements or not. Preserve this agreement. It's almost to the point that may be an illusory contract because I'm not sure she really gave anything to consideration since I think the department probably have a duty on this anyway to investigate any parent that's brought before them to see prior to termination. But anyway, we have this mediated settlement agreement back in September 2018. Based on that mediated settlement agreement, they present to the court what they report to be a final order. In that final order, attached to it is the mediated settlement agreement. It's incorporated in that order that they report to be a final order. But the agreement was whatever, do an interim order for the sole purpose to go around the Texas Family Code requirement of you have to have a final order entered prior to the dismissal date. So the interesting question is the final order back from 2018 naming the Department of PMC and the mother of possessory, is that a final order or is it an interim order? If it's an interim order, then there was no final order entered prior to the statutory dismissal date, which means the court would have lost jurisdiction in the case of automatically dismissed. If it is a final order, then wherever that's MSA is incorporated into that order of 2018, and it's gone. It's not an agreement anymore. Subsequent to that, the lawyers filed a motion to PA to validate the MSA. Then at that point, the department takes a position, oh, it's a final order, and all y'all's motions are too late. 30 days in front. So that was the week 2019. 2019, they filed a motion to modify what they purported to be a final order, which according to the MSA was an interim order. If it's an interim order, there's nothing to modify. If it's a final order, then to continue to use the MSA as an agreement is not, I don't think, correct. So it was incorporated and gone. So then they filed a motion to modify, I believe in June of 2019. And for the modification, there has to be some substantial material change since the time of their final order to point to the final order. And there's nothing in the record of any material substantial change. They come to court in, I believe, in August of 2020. Again, talking about the mediated settlement agreement that would require her to do it. So it's rather more complicated. So I think they have a problem either way. If it's a final order, it's not a final order. If it's a final order, the MSA is gone and it's improperly trying to make her live up to an agreement they didn't live up to. And if it's an interim order, which according to the MSA it was, then the statutory timeline ran without a final order being entered and a case started. So that would make that order, whatever it was, null and void and nothing modified when the department filed in August 2019. It's a little more fluid than it's I mean, I think they're probably right.
Well, I will say this, and I can't remember the name of the actor right off the top of my head, but in the movie No Country for Old Men, the sheriff says, if this ain't a mess, it'll do till the mess gets here.
Yes. Sir. But so I think all that kind of relates back to whether or not you voluntarily and knowingly, willingly execute August 4th, 2020, that 2020, which made the basis of the order of the final order of assignment of the school.
I see what you're saying. So is it your position then, how in the world can you sign an affidavit of relinquishment after a final order has already been entered?
That, and then how you compel to do that when the MSA doesn't exist? Because if there wasn't a final order or an interim order, that was part of the agreement. We're going to file an interim order to circumvent the dismissal date, and we're going to call it a final order. So I'm not sure what it is, but either way, if it's a final order, MSA doesn't apply because it's gone. If it's an interim order, I think jurisdiction of the court left if the dismissal date, because there was no hearing commenced or final order entered prior to the expiration. It's 18 months. I think they're already in extension at that time. So I'm not sure if they're calling which one they're at.
Department's response?
Oh, I do have a question. An amended motion for new trial was filed after 5 o'clock yesterday. So we're not, my understanding, clearly the hearing is at 9 o'clock this morning. My understanding that we're not hearing the amended motion for new trial, we're only here. And I haven't looked at them to compare the differences between the two. My concern is that we don't have notice of what's in the amendment because it was filed after business hours yesterday. And so I don't know what the differences are, but I don't think we're prepared to go forward on the amended motion for new trial from the, elements, just the original motion for new trial. I just don't know what the differences are.
There's really no difference. I basically copied one certificate file, but I did have some verification, I think, for field purposes or make it, when this type of motion for new trial needs to be verified, and she verified it. Actually, I'll just copy this allocation certificate.
And I haven't seen it either, Your Honor. I was off from about 4 o'clock yesterday, certainly.
And I was at mediation until 7 last night. That's the only reason I saw it, because I was looking at my phone and it popped up.
I've got some that they are correct. I got home with the court too, and they were filed earlier after I met with her yesterday.
So, well, I guess the easiest thing first is, so you're saying if he files this, even if it doesn't change any of his grounds on the new trial, it just adds a verification that you're still entitled to additional time?
Can I take a look at it?
Sure.
first and before I respond to that?
Because basically all we're going to do then, if you're entitled to more time, is it just gives you more time to respond to the same grounds apparently that have already been alleged. And they say in the law, time cures most errors. Least notice errors.
apply for one.
Sure. That good. And plus, I don't know who's listening to this, but we're live. Anyway, you ready? All right, go ahead.
Judge, based upon the filing of the amended motion for new trial, the department will request one.
With that, I'm not sure what the difference is. Of any substance.
Do you want to go forward with the original motion for the trial?
I think there are rules that has to be, it's supposed to be verified when you bring it, this type of motion. to the trial. So like, if you want to change it, not for the subject, was it verified?
You're not correct.
Well, good, I'm under the guidelines of Court of Appeals as of yesterday, I got the May 17th, if I'm not reading. The letter that says don't come asking for any more, so. They want to actually, it needs to be, I just asked for it to be short. I don't think there's any substantive change other than verification myself.
What is it? What happens when you get out of civil practice? Because we've been doing nothing but felony. What is the time on a motion for new trial? Is it for notice? Is it 7 or 10 days?
I don't remember. It's been a long time, to be honest with you, Judge.
Probably 3 days.
Three. Okay, I was wrong.
3 days for a motion.
Is it 3?
Yes, ma'am. But I must say, any more time, I said, the only change I made was verification.
No, but I mean, I think you'd agree if there wasn't a verification, then that motion for new trial wouldn't have been maybe I'm using the term incorrectly, a legitimate motion for new trial because it wasn't verified. Unless there's some case law that says, hey, you can cure it. I don't know if y'all want to spend a few minutes looking at case law or not. And I'd rather hear it today, but I don't want to get down the road and say, hey, he didn't have a verified motion on file. And if you would have just waited 3 days, you could have avoided another mess.
So I'll ask the court if it wants to reset it. I have to have a brief file by May 17th.
I understand. No, I understand your position. But let me ask you this, in in this motion for new trial, the one that's now verified, which I would assume is the same as the previous one, and I've got it in front of me. I don't see, and maybe it doesn't need to have any, but I don't see any allegations of what you raised earlier as a ground. In other words,
Your Honor, yeah, that's the other issue. If we are going, if he's going to be allowed to argue the MS, all the way back to the MSA.
Or outside the motion for new trial.
Yes, all that's been raised in this motion is that affidavit voluntarily.
yeah, that's what I wanted to ask you about, Mr. Harrington, is that basically the only allegation I see is she was pressured into the agreement.
I understand that, I thought about doing it, and then what if I do, I will, but in my mind, all this is related, because if she's under a MSA, the contract is not valid, but she believes, and it is told that she has to do it because of the MSA, that goes to her, not giving up her rights willingly, so I think we're all related, but it is more strict.
But Judge, I would argue that that day on August 4th, it was as kind of the court pointed out, a new deal.
Hold on a second. That's why you have an attorney. I'm sorry, what did you say again?
The day on August 4th, the affidavit voluntary relinquishment was signed, and the post-termination contract was negotiated, that was in essence. As the court pointed out, a new deal.
But you know, the way I think I looked at this back then and the way I kind of look at it now, and I'm not trying to put words in your mouth, Mr. Harrington, but it's almost like in criminal law, fruit of the poisonous tree. Because once you pick that poison apple, anything that happened after that is contaminated by that fruit of that poisonous tree, which would have been either a pressured into, well, and maybe y'all didn't raise this. I know I talked about it earlier, pressured into MSA because you relied on the coaching. That was my big concern when we first started this, or pressured into the relinquishment based upon an MSA that wasn't enforceable because it wasn't a final, or I guess that the court had lost jurisdiction already because it wasn't a final order. I mean, is that what you're getting at, Mr. Harrington? All of this is fruit of the poisonous
Yes.
tree, but where was the original poison, I guess?
The MSA.
Okay, so you're not going behind that, so I'm not going to worry about that coaching. That worried the court at the time. So the poison you say happened at the MSA.
And forward.
Okay,
And not a single word in mentions the needed substance.
Well, again, it goes to first thing mind, the voluntary. It's all related.
Except we negotiated a new deal on that day.
If I recall correctly, on that same first day though, our lawyer says, well, I'm gonna withdraw my litigation, and I say, go forward. And I believe that's the record. So if we brought up that, it's still been something in everybody's mind, but MSA is now effective.
and I mean, I could see how that could be included, you know, when you file them, again, I go back to criminal law because that's my wheelhouse. When you file a motion to suppress, you just say that my client's rights have been violated, Fourth, Fifth, Sixth Amendment rights, Article 1, Section 9, and so forth. You don't get into individual specifics. So if that includes she was pressured into it, all the factual allegations in that would relate to why she was pressured. Is that?
That's my, I thought about doing more stuff, yeah, that's all, I think it's all related, and it's just like you say, it's gonna start with MSA and everything after that was poison. I sort of told earlier, which poison they wanted to have it, is it poison that wasn't found, or poison that wasn't found. I think it's both ways. But I think that, I was thinking as the court was, I'm thinking MSA has been the poison where it's when it went wrong, and then it came forward. And everything is still related to the MSA.
Judge, I would argue this is very complete with some specificity.
And that is not necessarily, the criminal case has fruit of the poisonous tree.
No, I related it to that. I understand, you know, you suppress it if it is fruit of the poisonous tree, but I'm just using that.
As an analogy.
That's what I was looking for, just an analogy. And that's why I say it's like that. I mean, just to kind of help me wrap my mind around it. But you are correct. In civil law, you do have to plead the specificity. So,
On request. On request.
I'm requesting.
so here's what I'm going to do. Kevin, he's got a May 17th deadline. What dates do we have? That's my son's 16th birthday. I'm sorry, y'all.
Yesterday.
If they're priors. And what you need to do is they won't take long.
Monday morning, 9 a.m.
What one?
The 3rd.
I'm in mediation.
Hold on. Yeah, I'm fine. At what time? 9. I'm over here at 9. Seventh at 9 a.m. And so if it's 3 days, that's, I mean, so if you did file anything between now and then, I guess you still have time to get it in within your 3-day window. Yes, sir. May 7th, 9 a.m.
Yes.
And I'm just gonna let y'all know, I'm gonna do a little research, little legal research between now and then, try to be more armed, now that I kind of know what y'all's arguments are.
I was gonna say that to the end, but I thought I should tell that kind of front to that front door. You know, I think it's your initial question possibly. Say used to affect that file, they reported the file order that and it was incorporated into that order and attaches it. I think that included the MSA. That point, and then after the 18 months passed, that's when they filed a motion to modify based on that big final order. CPS took the position and that was the final order. That's when we were attacking the two of the lawyers saying their motion's not timely filed. Judge court where lost jurisdiction. So then they filed a motion to modify or I think not final or on the original, but it was. That was done solely for the purpose to get around the 18 month statute. Not sure how that works. A lot of stuff I never heard, but never worked. I thought this would be, the more you get into it, as you say, it's so. And then there's no change of circumstances in the time the final order, it was one in October 28th, the time they called a motion to modify. Other than that she maybe relinquishment, and everybody's still talking about this thing. And I think it's, of course, you can look at the other thing. I'm not sure the department gave fair consideration when they have the obligation to do that anyway, exchange or something said back in court, this is like a law school exam. I don't even remember one thing.
Unfortunately, it's cases like these that make case law, but we'll try not to make it there. All right, thank y'all. I'll see y'all. May 7th, 9 a.m.